Good afternoon, everyone. My name is Colin Walker. I'm an attorney at Fairfield and Woods in Denver, and I'm also the author of the C-Level Law blog. And I'm here today with my good friend and colleague, John Applin. John's an experienced member of the board of directors of a number of companies, and as well as the chairman of a number of boards. And he's going to talk to us today about how the board of directors interacts with its employment lawyer. But John, could you take a minute or two to introduce yourself, please?
Thank you, Colin. I'm pleased to be here today. I've been fortunate over my career to serve on probably 40 to 45 public, private, and not-for-profit boards. So I've got a lot of board experience, mostly as a chairperson, if not chair, at least chair of the audit committee. So I've seen a lot of typical management issues that come and confront the board.
And have you dealt with lawyers in the course of your career?
Oh, yes, many lawyers.
And what kind of lawyers have you dealt with?
You know, really the entire gamut, from general counsel to transaction specialists to patent attorneys and to a lot of employment practice attorneys.
Okay. And, you know, it used to be that lawyers don't specialize as much as they do now, but it's really gotten to be something that we do. We specialize in various fields. And is that something that's important to you as a member of the board?
There's absolutely no question, particularly with employment law, because that is very technical, very specific. And if an issue comes up, it's very easy to make an unintentional foot fault where you do something incorrect that creates problems in the future. So I really, when it comes to employment matters, the first call I make is to my employer. Okay, so what do I need to do to handle this correctly?
Yeah. And we were talking the other day about this, and we talked about some examples where you go to employment lawyers for advice. Could you give us an example?
You know, one area that frequently comes up is sort of romantic relationships between C-level executives, between the CEO and subordinates, and very common in organizations. And I have seen it in public organizations. I've dealt with it there. I've seen it in private organizations, even seen it in volunteer organizations, not-for-profits.
When that comes to your attention, what do you do?
First thing I do is call my employment lawyer and say, okay, what should I do here? Should I disclose this information that I now have, which generally comes either through a whistleblower call or through a private conversation with a third party who's making me aware of a situation? And I then have to determine, should I share this with the board? If I do, could it impact the board's perceptions of the C-level or CEO? And so I really want to know how I should handle it. Okay. Because it's very tricky.
And let's talk about, drill down into some of the concerns that you might have. Just give me a second here. This is a slide that we came up with to kind of illustrate some of the concerns, but could you expand on that a little bit?
You know, the biggest issue is it seems like the board is the last to know. And if there's a romantic relationship that's going on, particularly with the CEO, everybody else is aware of it. It creates morale problems, it impacts productivity, it can lead to all sorts of conflicts of interest where the CEO's judgment might be affected. You know, they will travel together, perhaps. All sorts of issues come up. And those issues inevitably create potential legal exposure for the company and for the board.
Okay. But, you know, I assume that other employees might be resentful, might think they're being treated unfairly because there's this relationship. Is that something you think about?
Oh, yes. It almost, when I get a direct complaint or issue arises, it almost always comes from another employee who feels a decision was made that adversely affected them and benefited one of the people in the relationship.
Yeah. And then I'm assuming that productivity can be affected if there's that kind of relationship. They may not be working on the business issues as much as they otherwise might.
Yeah, it just creates all sorts of problems, including it leads to credibility of the CEO in a leadership role. It's just poor judgment.
Okay. And are there situations when you become aware of that situation where you would consider terminating one or both of the employees?
I have.
Okay. And let's talk about that a little bit, because there's some legal issues that as your employment lawyer, I would want to discuss with you before you make that decision. And this next slide illustrates that. There are laws out there which could protect employees in those situations. And one of them are lawful off-duty statutes, which, and they basically say that you can't fire an employee for doing something off-duty, which is lawful, And almost every state has these laws now. There's a few exceptions, but most of them do. In Colorado, where we are right now, definitely has one. But the classic example is a smoker, someone who smokes outside of work, and the employer might be tempted to fire them because they want to reduce insurance costs or something like that. And these laws say, well, that's not right. If they're doing that off duty and it's lawful, then you shouldn't be able to fire them for that reason. Similarly here, there's nothing illegal about a romantic relationship between employees. And if they're doing it off duty, and then one could argue that these laws will protect them. Not to say you have to tolerate it in the office, of course. And if that's the case, then that would be an exception to the law.
Yeah.
The other kinds of laws that could provide protection are laws which protect spouses. And again, many states have these laws, and Colorado does. And it basically says that you can't fire someone simply because they're the spouse of another employee, with certain exceptions, one of which is when there's a supervisory relationship between the employees, which may well be the case in the example we're talking about now. Is that fair to say?
Exactly. And what you're pointing out, Colin, I think is a really good point. I've been on boards from Connecticut to the West Coast, and the employment practices are very specific to the states. And what I might be able to do in Connecticut, I may not be able to do in the state of Washington. So I really need the guidance of somebody who knows the state laws and can provide, just bulletproof legal advice on the matter.
Well, that's a great point, and it'll be the point of a future blog post. The laws vary state to state, and sometimes it's very hard to keep up with them, especially if you have an operation, and I'm sure you have, across the country.
And it is especially true because a case will come up and it might change the case law with respect to how you can deal with it. So it really makes your reliance on your employment lawyer very, very very significant.
Well, let's talk a little bit more about the law. And this is kind of the other side of the coin. I mean, there are some laws that could potentially protect employees in a romantic relationship. There are other laws that could really hurt the company because of this. Yeah. And the main one is, you mentioned before, sexual harassment. And I know we're talking about a consensual relationship, but sometimes those turn into a situation where they're allegedly not consensual. And very often it's a case where everything's fine until someone breaks up with somebody else. And then all of a sudden it's not consensual and you get a complaint.
You get a complaint. And obviously the person who usually feels that they've been hurt by the relationship or the breaking off the relationship is going to claim they were forced into it. They were coerced into the relationship. And that's a bad spot to be in.
Right. And obviously the sexual harassment laws could come into play there and often do. The next theory I want to talk about is called quid pro quo. And if you know Latin, it means this for that. And what it means is something in exchange for a romantic relationship or romantic activity. You're going to get the promotion if you engage in romantic activity with me. That's called quid pro quo, and it's unlawful. And the discrimination harassment laws come into play there as well. And the last one I'll talk about at this time is retaliation, the idea being that someone comes and complains about sexual harassment. And maybe it's someone that was formerly in this relationship, or maybe it's someone else that feels harassed because they're witnessing romantic activity. They come and report to management, and then management takes some action against them, fires them, demotes them, or something like that. And this is one that employment lawyers really pay attention to because it's very often the most damaging claim that you have if you get into litigation. So, and there's a lot more we could talk about here, of course, but those are kind of at the top of my list of things that can get the company in trouble when you get into a situation like this. Now, let me ask you this, John. Certainly understand the concerns that you have and that we've discussed. Would it matter to you, would it change anything if the people that were involved in this relationship disclosed it to you?
Honestly, I don't think it would. And the reason for that is I think that the culture that is created in the organization is of utmost importance. And I think if you have a situation where a CEO or C-level executive is involved in a situation like this, it leads to all sorts of credibility issues for the organization. People expect the board to take action when they see these things happen because they're not right. Whether it's legal or not, you get into some gray areas, but the situation is not right. May not be illegal, but it needs to be addressed.
Right. From a management perspective, it needs to be addressed.
Certainly,
I understand where you're coming from, and we respect you. imminently. That's why we're here talking to John. I will tell you, there is a different school of thought on this, that if it's disclosed, it can be a productive relationship. There have been many examples that, a couple worked in the same company and had a productive relationship, but not very often.
Yeah.
Right? I mean,
And it really gets to the specifics. For instance, if it's a romantic relationship, both parties are unattached, both are single, it's a little bit different.
Yeah.
However, it never is that way.
Yeah.
They're not uncommon for one or both to be married.
yeah, and that kind of ups the ante a little bit.
I've had spouses call me.
Yeah.
And,
It's risky business.
company, it's just,
It's risky business. So you would say, I presume, that, and things happen, let's face it. I mean, people work closely together and there is chemistry, and sometimes those feelings start to arise. And I imagine you would say, if that happens, one of them needs to quit.
yes, that's my view. It would be more unique circumstances for them to continue to work in the same organization. That would be more unique.
Okay,
I've
and
not seen that happen.
that's certainly a valid thing to do, and people, it's happened many times. I will say this: if you find yourself, you executives out there, in that situation where you're starting to have romantic feelings for a coworker, I think it would be best to disclose it. I know that's hard. I know you're afraid of getting fired and that kind of thing, but I think it would be much worse to hide it and not let the board know, and to continue doing your job, which may involve compensation decisions for this other person, disciplinary decisions, other kinds of working relationships. The hiding of it, I think, it just makes things worse.
Colin, the board may be one of the last to know, but I can tell you, you just can't keep secrets in an organization.
Yeah.
You really can't, not of that nature. It's just too hard. And they always get found out, and they always almost inevitably lead to bad outcomes.
Something bad.
Something bad happens.
Well, I think that's all the time that we've got for now. John and I are going to go treat ourselves to a couple of cocktails, and I hope you are as well if you're into that kind of thing. And I hope you'll join us here again at Sea Level Law.
Thanks, Colin.
Thank you, John.